Non-debtor third-party releases are one of the most controversial areas with regard to the confirmation of Chapter 11 reorganization plans. That will be the topic of our discussion today on Rochelle's Daily Wire Video Edition. As background, we need to say that last year, the Third Circuit clearly held that the Bankruptcy Court has core jurisdiction to issue these non-debtor third-party releases as part of confirmation of a Chapter 11 plan. In other words, in the Third Circuit, these non-debtor releases are part of a final order entered by the bankruptcy judge. In my column, Rochelle's Daily Wire, on the ABI website, we have reported a very significant case by Chief District Judge Colleen McMahon from the Southern District of New York. This was a decision in a very important case of Purdue Pharmaceuticals, where the company and ultimately its officers, directors, and owners are going to try to get releases for claims made against them for distribution of opioids. Well, what happened in the case before Judge Mann was procedurally different, and perhaps that's important when compared with the Third Circuit decision. Because what Judge McMahon had before her was an appeal from a preliminary injunction where the bankruptcy court enjoined creditors and others from bringing these opioid lawsuits against owners, officers, and directors of Purdue. She held that, at least with respect to a preliminary injunction, the issue was not core because it did not arise in or arise under the bankruptcy code. And that's important because it means that because it was not core, the bankruptcy court could not enter a final injunctive order as part of a preliminary injunction. Well, here is what has me worried or concerned or, frankly, perplexed. Question is this: as sure as God made little green apples, the owners and officers of Purdue are going to contribute several $billions for a Purdue Chapter 11 plan, and they are going to be given in the plan these famous third-party non-debtor releases. The question I have for you is this: in view of Judge McMahon's order, does the bankruptcy court have core jurisdiction to enter these non-debtor releases as part of a Chapter 11 confirmation? Now, core or not core is very important, because if it is not core, it seems to me that the bankruptcy court cannot enter a final order of confirmation, and in other words, the plan cannot be consummated unless and until there has been a de novo hearing and a brand new order entered by the district court. Well, as I said, I'm not sure exactly what Judge McMahon's decision means, but those of you interested in Chapter 11 practice, please go and read the decision. It is attached to my story on ABI's website. As I said, I'm Bill Rochelle. I'll be back same time next week. Meanwhile, stay safe, be home, because I want to be sure everybody is healthy and back online same time next week. Good day.